All right, so get ready because today we are diving deep into the world of causation.
Oh, yeah.
Specifically, how the concept of cause plays out in the legal realm.
It's a huge topic.
It is. It is.
Yeah.
And to help us navigate this tricky terrain, we're turning to excerpts from the Stanford Encyclopedia of Philosophy's article on causation in the law.
That's a good one.
It is dense, I'm not going to lie, but, we're going to break it down. We're going to unpack it.
Yeah.
Our focus today is going to be on the Anglo-American legal system, particularly criminal law and tort law, where figuring out who is responsible for what harm is, well, essential.
Absolutely.
Right.
Yeah. The article kicks off with this two-tiered approach to causation that you see in a lot of these systems.
Okay.
And the first tier is cause in fact. So did the defendant's action actually make a difference to the outcome?
So enter the famous but-for test.
All right.
Would the harm have occurred but for the defendant's action?
Yeah. Sounds simple, right?
Deceptively simple.
Yes.
As any good philosopher knows, the simple questions are often the ones that lead to the most problems.
That's right.
So the article highlights 4 major issues that can make applying this but-for test really tricky. And the first one they talk about is the proof problem.
Right.
How do we rewind the tape of history and prove with absolute certainty what would have happened if the defendant had acted differently?
Yeah.
They give the example of a case, New York Central, RRV Grimstad, where a crewman falls overboard.
Right.
There's no life preserver on board because the defendant had culpably destroyed it. But would a life preserver have actually saved him?
Who knows?
Could someone have reached him in time, even if there was one?
Right.
So many uncertainties, right?
You get into this game of what ifs,
Yeah.
which leads to problem number 2, the vagueness problem.
Right.
Which alternate reality are we even comparing to when we use this but-for test?
Right. And what are we holding constant?
There are just so many possibilities.
Yeah.
The article brings up Denny v. New York Central RR as another good example. So in this case, a train is negligently delayed, and then much later, further down the line, it gets hit by a flood.
Oh, wow.
Now, would the flood have happened but for the delay? Well, technically, yeah.
Technically.
But it seems absurd to hold the railroad liable for a flood because of a delayed train.
Yeah. So that kind of gets into the over-inclusiveness, right?
That's right.
The but-for test can create this causal connection where maybe intuitively we don't think there should be one.
Yeah.
And then on the flip side, we've got the under-inclusiveness problem.
Right. What about all those classic overdetermination cases? Where you've got multiple things that could have each caused the harm on their own.
So give me an example.
Sure. Think of like the classic 2 fires that both converge and destroy a house.
Okay, yeah.
So would the house have burned down but for either fire alone? Well,
Yeah.
no.
No.
But it doesn't seem right to let both arsonists off the hook just because they happen to act, at the same time.
Right.
And the article goes on to talk about preemptive cause cases where one event preempts another that would have also caused the harm, and asymmetrical cases where, say, you've got a mortal wound that's inflicted alongside a non-mortal one.
So, like, people v. Lewis.
Exactly.
Right.
Does the person who inflicted the less severe injury escape responsibility simply because a more serious injury happened to occur at the same time?
So all these examples show how the but-for test, it's appealing, right?
Yeah.
It's simple.
It seems simple.
But it can lead to some outcomes that are counterintuitive
Right.
or even unjust.
And to address these shortcomings, the law has come up with some modifications and alternative tests,
Okay.
which the article helpfully outlines for us.
Right.
So we've got things like the INUS and NSS tests,
Okay.
attempts to break down causation into necessary and sufficient conditions.
Yeah.
And then there's the substantial factor test, which asks, was the defendant's action a significant contributor to the harm?
Right.
Moving away from that strict but-for analysis.
It's getting a little more nuanced.
A little more nuanced.
We're adding some shades of gray.
And we can't forget the lost chance approach.
Right.
Particularly relevant in medical malpractice cases where negligence might have, decreased the victim's chance of survival.
Right. Even if it wasn't the sole cause of death.
Exactly.
Right.
And for a philosopher, it's really interesting to see these modifications not just as legal tools,
Right.
but as reflections of different underlying theories of causation. We're kind of seeing metaphysics in action here.
It's like we're getting into the philosophy of law.
Exactly.
Right. So even if we manage to navigate all the complexities of cause and fact, our legal journey isn't over yet.
No, it's not.
Because next we have to enter the realm of proximate cause.
Oh, boy.
Dun, dun, dun.
Welcome back to our deep dive on causation in the law. As we saw in part 1, even if we can pinpoint cause and fact, using that but-for test and all its variations,
Yeah.
the law doesn't just stop there.
Yeah.
It's like we've climbed this one intellectual mountain only to find there's an even bigger one looming in front of us.
Right.
Proximate cause.
Proximate cause. Okay.
Yeah.
So even if we figured out that the defendant's action was a cause and fact of the harm,
Right.
the law wants to know, was it a proximate cause
Okay.
or a legal cause? Was it close enough, substantial enough to actually
Now-
hold them responsible?
So it's not just like, can we trace a line from the action to the harm?
Right.
Is that connection the kind that the law should recognize and do something about?
Exactly. And this is where things get really, really interesting for a philosopher, I think.
I think so too.
So the Stanford Encyclopedia article does a nice job of breaking down the different types of proximate cause tests.
Okay.
And it puts them into two main categories: policy-based tests and cause-based tests.
Okay. So are we basically saying with these policy-based tests, let's just set aside for a minute the actual, like the intricacies of the causal chain.
Right.
And just ask, what result makes sense here? What's fair?
What would be the best outcome for society? What serves justice? What serves a well-functioning society?
You got it.
Okay.
So one example is what's called the general policy test,
Okay.
where courts kind of weigh various social interests in each specific case.
So it's kind of like a balancing act, right?
It is.
Like, how do we balance the need to deter harmful conduct
Right.
with, being fair to the defendant?
How do we make sure victims are compensated? What about the impact on different industries?
Yeah.
So all sorts of factors get taken into account.
Okay. And then we have what are called rule-based policy tests, right?
That's right.
And these are basically like pre-established rules.
Yeah. Rules that are meant to achieve certain policy goals.
Yeah.
So the article gives some historical examples, like the year and a day rule for homicide.
Right. If the victim didn't die within a year and a day of the defendant's action, then tough luck.
Exactly. No longer legally responsible,
Right.
no matter how clear the causal connection might seem.
So black and white.
Very black and white.
Right.
And then there was the first house rule,
Right.
which basically said railroads are only liable for fires caused by their trains up to the first house that's ignited.
Oh, interesting.
So not any subsequent ones that might catch fire.
Okay.
Again, not really about pinpointing the true cause, more about managing risk
Right.
and kind of protecting certain interests.
So it's fascinating, I think, how these rules kind of reflect
Yeah.
almost a skepticism about the law's ability to perfectly mirror the
Right.
complexities of causation.
Yeah, it's like acknowledging that sometimes you just have to draw a line,
Yeah.
even if it doesn't perfectly align with, philosophical analysis.
Right. So these policy-based tests, they're not without their critics, right?
Of course not.
What are some of the criticisms?
Well, one of the big ones comes from folks who are really focused on retributive and corrective justice.
Right.
They're saying, look, legal causation shouldn't just be about achieving some kind of social desirable outcome. It should be about actually identifying who is morally responsible.
Who really did it?
Exactly.
Yeah.
If we want punishments to fit the crime and compensation to go to those who are truly harmed,
Right.
then we need a concept of causation that's, more than just a legal fiction.
Okay. Yeah. That makes sense. That's a good point.
Now, this critique might sting a little less for the next two policy-based tests,
Okay.
the foreseeability test and the harm within the risk test.
Okay.
Because while they're still driven by policy, they do try to ground legal causation in a factual assessment that seems a bit more relevant to moral culpability.
So they're kind of narrowing the scope a little bit.
Refining it
Yeah. Refining it.
to what the defendant could have anticipated
Yeah.
or what risks were inherent in their actions,
Okay.
bringing it closer to what we think of as moral responsibility.
Okay. So the foreseeability test, pretty straightforward, right?
Yeah.
Was the harm foreseeable?
Yeah. Could the defendant have reasonably anticipated that their actions might lead to that outcome?
And if not, it seems kind of unfair to hold them responsible.
Right. Like, we shouldn't punish people for consequences they couldn't have foreseen.
Yeah. And doesn't that kind of overlap with how we assess someone's mental state in the first place?
That's the redundancy critique, right?
Right.
Like, why are we asking about foreseeability twice?
Yeah.
Once when we're figuring out, did they intend the harm? Did they foresee it? Were
Mhm.
they reckless?
Right.
And then, again, when we're trying to figure out proximate cause,
It seems like we're doing double duty.
it does. But the Stanford Encyclopedia article suggests that maybe the foreseeability test can be saved if we think about it as addressing a particular problem,
Okay.
what they call the fit problem of mens rea.
Okay.
The idea is sometimes the harm that actually happens is a little bit different from the harm that the defendant intended or foresaw
Okay.
or risked.
So how does the foreseeability test help us with that?
Well, it helps us decide if the actual harm is close enough to the harm they were culpable for to justify holding them liable.
Okay, I'm following you.
So think as the classic example. Someone throws a rock intending to break a window,
Right.
but instead the rock hits a passerby,
Okay.
causes a serious injury. Well, they were culpable with respect to property damage,
Right.
but not necessarily with respect to bodily harm.
Okay.
So the foreseeability test helps us bridge that gap.
I see. I see.
It becomes a question of, did the type of harm that actually occurred fall within the scope of risks that they were culpable for creating?
I got it.
But some argue that this fit problem is actually better addressed by the harm within the risk test,
Okay, let's talk about that.
which really tries to tackle this question of alignment
Okay.
between the harm and the culpability.
So unpack that a little bit for me. How does this harm within the risk test work?
So instead of asking about foreseeability, it asks, was the harm that actually occurred the kind of harm that made the defendant's action negligent,
Okay.
reckless, or otherwise culpable in the first place?
So back to our rock throwing example.
Exactly. We'd ask, was the risk of injuring a passerby part of what made throwing the rock in that specific way wrongful?
Right.
If so, then even if they didn't specifically intend to cause bodily harm,
Right.
they're still responsible because the harm that did occur falls within the scope of the risk that they created.
So it's about kind of matching
Yeah.
the punishment with the wrongdoing.
Yeah, aligning the consequences with the culpability.
I like it.
It's got a certain elegance to it,
It does.
especially for folks who are really into that idea that justice requires a really tight connection
Yeah.
between what you're culpable for and the consequences.
Okay.
But, as with all of these theories of causation, it's got its limitations.
Okay. Like what?
It doesn't fully capture this idea of remoteness.
Remoteness. Okay.
Like, just because something was part of a chain of events doesn't mean we necessarily consider it a cause.
Right. Right. Like if my decision to have coffee this morning is a necessary condition for us having this conversation right now,
Right.
would you say I caused this conversation?
That's a great example.
Okay. Good.
It gets at this idea that some causal connections are just too weak,
Too far removed.
too attenuated
Yeah.
to really justify legal responsibility.
Okay. And what about, I mean, there are all these cases, right? The law loves to talk about these cases where a victim has some kind of pre-existing vulnerability.
Right. Like the thin-skulled man cases.
Yeah, exactly. Where
Yeah.
the victim's like extra susceptible to harm
Right.
and the defendant couldn't have known.
You have no idea.
So like if I tap someone on the head and they die
Oh, boy.
because unbeknownst to me, they had a thin skull,
Right.
am I really responsible for their death?
Right. That's a tough one.
Right.
The harm within the risk test might suggest, well, yeah,
Yeah.
because death is kind of within the general risk of tapping someone on the head.
Right. Right.
But obviously, you couldn't have foreseen that specific outcome.
Right.
It was way out of the ordinary. But the law generally says you're responsible in those cases. The idea is you take your victim as you find them.
Ooh, that's tricky.
It is tricky. It highlights how, legal causation often has to wrestle with these competing intuitions
Right.
about, how much was the defendant really at fault
Right.
versus, how much did the victim's own, unique characteristics contribute.
Yeah. It's like we want to hold people responsible,
Yeah.
but we also want to be fair.
And proportionate.
Right.
Yeah.
Okay. And what about those cases where, like, something completely unexpected disrupts the chain of events?
Intervening causes.
Yeah. Yeah. So, like, let's say I set a trap to injure someone,
Okay.
but before they can encounter it, lightning strikes the trap,
Oh, no.
causing, like, a way bigger explosion than I ever intended.
Right.
Am I still responsible for the harm from the lightning strike?
Right. So the harm within the risk test might say, well, yeah, kind of,
Yeah.
because, the general type of harm, the explosion, is still the same.
Right.
But it does seem like common sense might say, well, hold on a second.
The lightning strike, kind of.
Yeah, that changes things.
It breaks the chain, right?
It seems to break the chain of causation.
Yeah.
So again, this shows how the harm within the risk test, with its really tight focus on just matching the harm to the culpability,
Right.
sometimes misses the nuances
Right.
of these, trickier scenarios.
So are we stuck then? Are we just like forever bouncing between these policy considerations
Yeah.
and these cause-based tests that never quite seem to get it right?
Well, not necessarily.
Okay.
Some very clever legal theorists have come up with what are called unified or one-tier approaches to legal causation,
Oh, interesting.
like a grand unified theory
Oh,
of
okay.
legal causation.
Ooh, now that's something I can get behind. Okay, a grand unified theory of legal causation. Tell me more.
So these unified theories are trying to get past all the back and forth and
Right.
find like one single powerful concept of causation
Okay.
that can answer both the cause and fact questions
Yeah.
and the proximate cause questions.
So instead of having that two-step process,
Right.
we just have one big framework
Yes.
that captures it all.
Yeah.
That's pretty ambitious.
It is ambitious, and there are a few contenders for this,
Okay.
unified theory crown.
Okay.
One idea, and we touched on this a little bit earlier, is aspect cause, but like a more robust version of it.
Okay.
Remember how we were talking about isolating that specific aspect of an action that makes it negligent or culpable?
Right.
Well, aspect cause as a unified theory basically says only that aspect can count as a legally relevant cause.
okay, so back to our rock throwing example.
Yes.
We wouldn't just ask, did throwing the rock cause the injury?
Right.
We'd have to zero in on this specific thing about the throw.
Exactly.
It made it wrong.
Like, was it reckless?
Yeah, but was it like in a crowded area?
Were they throwing it towards people?
Right.
Yeah. And if that aspect was necessary for the harm to happen,
Then we've got causation.
then you've got legal causation. If not, then no causation, even if the act itself, in some broader sense played a role.
Okay. So it's really like fine-tuning the analysis.
It is.
It's like, what about the action was wrong?
What was the morally salient feature?
And was that the cause?
I like that.
It does seem to fit pretty well with
Yeah.
our intuitions about, when someone should be held responsible.
Like, if we're going to hold you liable, it should be for the stuff that you actually did wrong.
Exactly.
Not just because, oh, you happen to be involved in some chain of events.
Right.
Okay. What else? What are some of the other contenders for this unified theory?
So another one takes this kind of primitivist approach.
Or primitivist approach.
It basically says that causation is this fundamental concept that we can kind of recognize,
Okay.
but we can't define it precisely.
I like that.
It's like that famous line about obscenity.
Oh, yeah. I know it when I see it.
Exactly.
Yeah.
I can't define it, but I know it when I see it.
Yeah.
Yeah.
Okay, but how do we make that into a legal standard? Right. So the key here is that this theory sees causation as a matter of degree.
Okay.
One thing can be more of a cause than another thing.
Right.
So for legal purposes, we just got to draw a line somewhere
Okay.
on that spectrum
Okay.
to separate the substantial causes from the insignificant ones.
This is kind of like a substantial factor test, but applied to everything.
Exactly, to both cause in fact
Right.
and proximate cause.
Okay. So we're just looking at how strong is the link.
How substantial is it?
Take everything into account and then decide, is it enough
Does it cross the threshold?
to hold you liable?
Okay. So it's elegant.
I mean, it's simple.
It's simple.
Right.
Yeah, you don't need these super precise definitions or like
Yeah.
multi-part tests.
Right, right.
But it does rely pretty heavily on,
Yeah.
what we think counts as substantial.
It seems subjective. Right.
It can be subjective, and that raises questions about consistency, fairness.
Right.
Like, are judges and juries going to apply it the same way?
Right.
It's a tough one.
It's tricky. Okay, so we've got aspect cause. We've got this kind of like
Yeah.
primitivist approach.
The I know it when I see it.
Right. Is there anything else?
Well, one more that might appeal to, the folks who are into hard science.
Okay.
The physicalist approach.
Physicalist. Okay. Like physics.
Like physics.
Okay.
So this one tries to root causation in those hard sciences.
So we're talking forces. We're talking energy transfer.
That's right.
We're talking like chains of physical events.
That's very concrete.
It's a very concrete. I like it.
The idea is that causation just boils down to those physical processes.
Okay.
Did the defendant's actions set off this chain of events
Yeah.
in the physical world that led to the harm?
Yeah.
If so, you got causation. It's like dominoes, right?
Yeah. Yeah.
One thing knocking into the next.
Okay.
Until you get to that final outcome.
I mean, it seems pretty clear.
It is clear.
And it seems like it handles some of those tricky overdetermination cases pretty neatly.
Right. Like if two fires merge to burn down a house.
Yeah.
Well, each fire as a physical process
Right.
contributed to the outcome.
So they're both causes.
They're both causes. But the physicalist view, even though it is appealing in how clear it is,
Yeah.
might struggle a little bit when it comes to human agency
Right.
and the fact that, the world's a messy place.
Like, how do you account for intentions?
Right.
and omissions
Yeah.
and intervening causes.
This starts to get a little tricky.
It does. So, I mean, it seems like all these unified theories, they're really ambitious.
They are.
They're interesting,
Mm.
but they're still kind of works in progress.
That's right.
Yeah.
And the debate over how we should really understand legal causation,
Yeah.
that's far from settled.
I mean, and that's what makes this so interesting from a philosophical perspective, right?
Well, absolutely.
It's not just, oh, here are the rules.
Right.
It's like, what is causation?
What is responsibility?
What is justice?
Yeah, the big questions.
So, listener, here's a final thought for you.
Okay.
What if everything is a cause of everything else?
Whoa.
What if, like, every tiny little event, no matter how small or insignificant,
Yeah.
is in some way a cause of everything that comes after it?
Like a butterfly effect?
Yeah, like the butterfly effect.
Wow.
Right? That the flap of a butterfly's wings in Brazil can set off this whole chain of events
Right.
that leads to a hurricane in Florida.
Right.
What if it's all connected?
It's mind-blowing.
It is. It's kind of scary too,
There's
right?
a little bit.
Yeah. But it makes you rethink how we try to, like, define and isolate causes.
It does.
Right.
It really does.
Maybe it's all just one big interconnected web.
Yeah. And every little action we take is sending out these ripples
Yeah.
through the fabric of reality.
It's amazing. And, I mean, isn't that the whole point of a deep dive?
I think so.
To push our thinking,
Yeah.
to challenge our assumptions,
Yeah.
and leave us with more questions than answers.
Absolutely.
So we invite you, listener, to think about that,
Yeah.
the interconnectedness of it all.
Think about the ripple effects of your actions
Yeah.
and the really interesting ways in which the law tries to make sense of this.
This big, messy,
Yeah.
causal tapestry.
The grand causal tapestry.
Until next time, fellow deep divers.